Good morning. It is 10 a.m. on December, excuse me, it is 10:32 a.m. on December 9th. I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin the meeting, normally, and I'm assuming we do have a sign-in sheet where in the meeting room, as well as anyone that may be attending online, if there's any public comments concerning today's meeting or agenda, we will revisit that at the end of the meeting. Ms. Bohannon, would you call the roll, please?
Tim Wheeler. Tim Wheeler. Can you hear me, Mr. Wheeler?
Mr. Wheeler, can you make sure the correct microphone is selected? It should say something like computer audio or something similar. Default mic.
We'll come back to you, Mr. Wheeler. Don Haynes. Randy Nash. Tracy Allen.
Here.
Scotty Porsche.
Here.
Wendell Naylor.
Here.
Chris Lee.
Here.
Mr. Wheeler, did you get it?
Mr. Wheeler, there should be I'm not in it myself, but from listening to some troubleshooting this morning, there should be a button of a microphone where you can select your audio options. There should be an option that indicates computer audio. Just make sure that's checked first. And if it is, and you're still having some trouble, my understanding is that you, with the invite to this webinar, there was a phone number. You should be able to call in as well. And that might be a little less comfortable. You may have to hold your phone up for the meeting, but that should be able to get you on one way or another.
Mr. Lee, should we wait for Mr. Mr. Wheeler to get his audio, or should we continue?
We do know he's present, and like Mr. Haynes, I guess while they're working on technical difficulties, do we have a quorum present until those two are able to come on?
Mr. President, we do have a quorum.
Okay. And Mr. Whaler, Mr. Haynes, if you can hear, if you get that fixed or you come in, just let us know and we'll make a note of that on the record. All right. First thing, I'll entertain a motion and a second to adopt the agenda for today's meeting.
Motion to approve.
Second.
Okay, I am assuming that Ms. Allen made the motion and Mr. Porch made the second, sounded like. Okay, all in favor, please responding by saying aye. Aye. Any opposed? Motion carried.
Mr. President,
Mr. Lee. Go ahead, Mr.
Was there a
Brown.
question? I'm sorry.
no, I was going to say just a couple of things since we're doing, I know this is the first one where it's all electronic, so just a couple of things. If you are speaking, just identify yourself for the record. And then also all votes should be roll call votes.
Okay. Ms. Bohannon, I'm assuming we need to do a roll call on the agenda, please, ma'am.
Correct. Tim Wheeler, Don Haynes, Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
It passes.
thank you. Everyone received a copy of their October 14th minutes in their package. I will entertain a motion and a second to adopt the minutes.
Move. Wendell Miller.
Tracy Allen, second.
Have a motion by Mr. Naylor, a second by Ms. Allen. Ask for a roll call vote, Ms. Lisa, please.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
It passes.
motion passes. We'll now go to our legal report. We'll turn this over to Mr. Bryant.
Good morning, board members. Thank you for sticking with us on these electronic difficulties. I know they're a pain to troubleshoot, but appreciate you all hanging in there. And I just want to make sure we don't add another one. You all can hear me just fine.
Yes,
Perfect. We were due for something to go right. So we'll start with the first one. It is complaint number 2025-054481. This case was administratively opened following a routine inspection conducted on September 8th, 2025. During the course of this routine inspection, the inspector observed the following. The establishment license for respondent establishment expired on August 31st, 2025, and was not renewed until September 3rd, 2025. Although it did not appear that respondent establishment conducted business during this time, the establishment remained open for business. Manager of respondent establishment apologized for the delay in submitting their establishment license renewal, stating they fully recognize the importance of maintaining compliance with state regulations. Respondent stated moving forward, they will ensure that this does not happen again and are taking proactive steps to prevent a recurrence of this issue. Based on the above, we'd recommend a $250 civil penalty, authorized via consent order, and a formal hearing if necessary.
thank you, Mr. Bryant. Any questions? None being heard, I'll entertain a motion.
I make a motion that we accept legal's recommendation. Wendell Naylor.
Tracy Allen, seconds.
Thank you. I have a motion by Mr. Naylor and a second by Ms. Allen to accept the recommendation of $250 civil penalty, authorized via consent order and formal hearing if necessary. Ms. Bohannon, would you call the roll, please?
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
The motion passes.
motion passes. Number two, Mr. Bryant.
Number 2, complaint number 2025-056141. This case was administratively opened following a routine inspection conducted on September 18th, 2025. During the course of this routine inspection, the inspector observed the following. An employee of respondent establishment allowed their funeral director's license to expire on June 30th, 2025. The employee did not meet the requirements to renew their funeral director's license until August 5th, 2025. During the unlicensed period, the employee is served in the capacity of a Tennessee funeral director for 4 decedents. Respondent replied stating that the employee recently went through a divorce and that the notification of the license expiration was sent to his former address. Respondent stated that the employee's ex-wife did not notify the employee that the notice was delivered. Respondent added that they, like the employee, believed that his license expired in 2026. Based on the above, we'd recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Thank you, Mr. Bryant. Any questions? None being heard, I'll entertain a motion.
Make a motion that we accept legal's recommendation. Wendell Naylor.
Scotty Porch, I second.
We have a motion by Mr. Naylor and a second by Mr. Porch to accept council's recommendation of $500 civil penalty, authorized via consent order and formal hearing if necessary. Ms. Bohannon, would you call the roll, please?
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
Motion passes.
Motion carries. Number 3, Mr. Bryant.
Number 3 is complaint number 2025-056151. This case was administratively opened following a routine inspection conducted on September 18th, 2025. During the course of the routine inspection, the inspector observed the following. Respondent is the employee from the preceding complaint who, again, just as a reminder, permitted their funeral director's license to expire on June 30th, 2025, and did not meet the requirements to renew their license until August 5th, 2025. During the unlicensed period, respondent served in the capacity of a licensed funeral director for 4 decedents. Respondent reiterated their response from the previous complaint. Based on the above, we'd recommend a $500 civil penalty, authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Any questions? I have no questions. The chair will entertain a motion.
I make a motion that we accept legal's recommendation. Wendell Naylor.
Do you have a second on the motion?
Second, Scotty Porch.
Have a motion by Mr. Naylor, a second by Mr. Porch to accept council's recommendation, $500 civil penalty, authorized via consent order and formal hearing if necessary. Ms. Bohannon, would you call the roll?
Tim Wheeler,
Here.
Tracy
Were you
Allen,
able-
Here.
Scotty Porsche,
Here.
Wendell Naylor,
Here.
Chris Lee.
Here.
The motion
Present.
passes.
All right, motion passes. I'd like to make a note on the record at 10:45. Mr. Wheeler's been here, but he has actively joined the meeting and we can hear him now. Number 4, please, Mr. Bryant.
Number 4 is complaint number 2025-056201. This case was administratively opened following a routine inspection conducted on September 2nd, 2025. During the course of this routine inspection, the inspector observed the following. Respondent had a price discrepancy on the Statement of Funeral Goods and Services and a price list. Specifically, the Statement of Funeral Goods and Services stated a grave liner was $1,500, while the price list listed the grave liner as $1,350, resulting in an overcharge of $150 for 2 contracts. Respondent apologized for the inconvenience of the influx grave liner prices and stated there had been a delay in communication and action was being taken to correct that information. Additionally, the website for respondent establishment listed an advertisement for pre-need planning. However, respondent was not registered as a pre-need seller at the time of inspection. Respondent stated that the information on the website has been updated so as to not reflect the offering of pre-need. Based on the above, would recommend a $500 civil penalty, authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Just one quick question on the 2 contracts for the overcharge. Do we know if the consumer's been refunded those?
We do not. The inspector, I don't think had a way to collect that information, and I'm not sure what the respondent establishment presented in way of that. So it wasn't included in the report. So I would say primarily don't know for sure, but that may suggest that possibly not.
Okay, I'm assuming that, I guess if that comes back up, we can hear that separately. I'll entertain a motion on this.
So moved, Mr. Wheeler.
Second, Scotty Porch.
Have a motion by Mr. Wheeler and a second by Mr. Porch for a $500 civil penalty authorized via consent order and formal hearing if necessary. Ms. Bohannon, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Aye.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
Motion passes.
Motion passes. And I'd also like to note for the record at 10:48 a.m., Mr. Haynes he's been present, but has got his technical difficulties fixed and is part of the meeting. Number 5.
Mr. President, I'm gonna have to recuse myself on number 5.
Mr. Naylor is recusing himself on complaint number 5. Thank you, sir. Mr. Bryant?
Number 5 is complaint number 2025-056271. This case was administratively opened following a routine inspection conducted on August 5th, 2025. During the course of this routine inspection, the inspector observed the following. An employee of respondent establishment was registered as a Tennessee pre-need sales agent. However, their pre-need sales agent registration expired on June 28th, 2025, and was not renewed at the time of the inspection, which again was August 5th. During the unlicensed period, the employee wrote 9 pre-need sales contracts. The employee replied, apologizing for the oversight, explaining that this was their first time going through the renewal process and that they were not fully aware of all the steps and requirements necessary. The employee stated it was not their intent to act outside of compliance or disregard the registration requirements. The employee provided that they have put measures in place to track the renewal deadlines and requirements to ensure that it does not happen again. Likewise, the manager of respondent establishment responded, stating that they first became aware of the registration lapse on August 5th, 2025 during the inspection. The manager stated it was their understanding that the employee erroneously believed his pre-need seller's registration would automatically be renewed along with the sales agent license. Respondent stated this was a genuine misunderstanding on the employee's part and that the expiration date has now been incorporated on the renewal calendar, so it is not missed in the future. Respondent stated that upon being made aware of the expired registration, the employee immediately began the paperwork to have the registration reinstated, was filed on August 13th, 2025, received on August 28th, 2025. Respondent stated they are aware that the employee had written 9 contracts during the unlicensed period and that they are working with the 9 customers to rewrite their contracts to ensure that they were executed by a licensed sales agent. Once the employee became aware of the expired registration, the employee stopped meeting with families and stopped executing contracts. Based on the above, would recommend a $750 civil penalty, authorized via consent order, and formal hearing if necessary.
Thank you. Any questions?
This is Mr. Wheeler. I had one question, and I guess it goes to probably Mr. Gribble. Where the employee stated they thought it'd automatically be renewed, is this something, though, that is much like with the state licensing of funeral director and embalmers, that when they get their license, they're sort of instructed on what the procedures are when it comes to renewal period? And is there an email or something sent to them, notify them that their license is about to expire?
Pre-need sales agents receive the same notification that the funeral directors and embalmers do on their renewals. They're open to about 59 days prior to expiration. They can go in court and renew. However, we've consistently over the years had a high number of pre-need sales agents that will at times let their license expire, as we've experienced with funeral directors and embalmers recently. But they do receive the same renewal notifications and instructions.
Okay. My other question would be, do we know if these 9 pre-needs that were sent in, have they all been corrected and signed by a licensed agent so that those pre-need consumers are protected?
We do not. The respondent didn't provide any follow-up information regarding that. Essentially, other than their intent to do so, there was no follow-up documentation to show that that had been accomplished.
Okay. That's all my questions.
I definitely think what Mr. Wheeler's saying and what I definitely agree with, we want to make sure that all those contracts are legal for the consumer, right, Mr. Wheeler? Which is something maybe we could follow up on.
Yes, or I'm glad to put it in my motion for council as part of what, if the board votes to agree that it would be a part, that I would like for the respondent to respond back to either Mr. Gribble or whatever, whomever, Troy or whatever, that they have gotten all these contracts, now legal, and that the consumer is protected if something was to happen.
Mr. Bryan, is that okay with you before we go forward on the motion?
Yeah, absolutely. If you need any help kind of forming that, I think you can make a motion essentially also, in addition to the civil penalty, respondent must provide information to the satisfaction of the department that those 9 pre-need contracts have been rewritten with a sales agent with a valid registration.
Okay, we have a motion by Mr. Wheeler to accept council's recommendation of a $750 civil penalty, authorized via consent order and formal hearing is necessary, and also for legal to follow up to make sure that those pre-needs are legal and validated. Do I have a second on that motion? Who was that, please?
Mr. Haynes?
Have a second by Mr. Haynes. Miss Lisa, would you call the roll on this, please, ma'am?
Tim Wheeler,
Aye.
John Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor. I'm sorry.
Recused himself.
Recused.
That's okay.
I'm sorry. Chris Lee.
Yes,
Motion passes. Sorry about that.
that's okay. Motion passes. Mr. Naylor, are you back online? Okay, I see Mr. Naylor back online. Number 6, Mr. Bryant.
Number 6, complaint number 2025056331. This case was administratively opened following a routine inspection conducted on August 19th, 2025. During the course of the routine inspection, the inspector observed the following. Respondent's manager permitted their funeral director's license to expire on January 31st, 2025, and did not meet the requirements for renewal until March 24th, 2025. Although records examined did not indicate that the manager had conducted any arrangement conferences or services during the unlicensed period, the manager remained as the manager of the respondent establishment without appropriate licensure. The manager replied, stating that they realized that their license was set to expire at the end of January, so began looking for courses in the first part of December. The manager began looking for courses like what they had previously taken, but then realized that the requirements had changed regarding 5 in-person hours. The manager stated that they searched around for CE courses, including asking the Tennessee, Kentucky, Georgia, and South Carolina boards regarding CE classes, but discovered none were being offered in December or January. Eventually, they found online webinars that were offered at $2 a month for 1 CE credit per seminar, but that with this timeline, quote, there was no way I could find to get the required CE before my license expired, end quote. The manager stated that fortunately, they did not have any funerals during the expiration period. Again, while the evidence obtained shows that no funeral occurred during the unlicensed period, the manager, who is unlicensed from February 1st, 2025 until March 24th, 2025, remained the manager of respondent establishment during this unlicensed period. So based on the above, we'd recommend a civil penalty of $750, authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Any questions? If not, I will entertain a motion.
So moved, Mr. Wheeler.
we have a second on the motion?
Second. Wendell Naylor.
Have a motion by Mr. Wheeler and a second by Mr. Naylor to accept council's recommendation, $750 civil penalty, authorized via consent order, and formal hearing if necessary. Mr. Bohannon, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
Motion passes.
motion passes. Number 7, Mr. Bryant.
Number 7, complaint number 2025-057821. This case was administratively opened following a routine inspection conducted on September 24th, 2025. During the course of this routine inspection, the inspector observed the following. The funeral director's license and embalmer's licenses for an employee expired on July 31st, 2025, and did not meet the requirements to be reinstated until August 11th, 2025. During the unlicensed period, the employee acted in the capacity of a funeral director and embalmer. Specifically, the employee was listed as the funeral director for 6 decedents on death certificates and the embalmer for 2 decedents. Likewise, the employee signed 1 statement of funeral goods and services, signed 2 authorization for cremation and disposition of human remains, signed 4 permits for cremation of human remains as the certification of person in charge of the cremation. In short, the employee had 15 instances of conducting action or signing documents that required licensure during the unlicensed period. Respondent replied stating that this is the first time the employee has worked on a lapsed license and provided that the employee was under a good faith basis that the renewal had been completed and thought they were only waiting on the wall certificates to arrive. Respondent stated the employee completed all continuing education requirements in June 2025 and that their records show she had logged into the court system on July 17, 2025 to complete the renewal application. Respondent stated the employee believed they had successfully completed the full transaction for the renewal of both the funeral director and embalmer's licenses. Respondent provided they now know that the employee did not successfully complete the final payment step in the process. Respondent stated that the employee, quote, did not receive any written communication by mail or email indicating that their license had lapsed, end quote, and only became aware of the lapse after wondering where their renewal wall licenses were. Respondent stated that due to this belief that the licenses had been renewed, the employee continued their duties as normal. Respondent provided that though the lapse was unintentional, they, quote, fully recognize that it is the establishment's responsibility to ensure that every licensed individual is properly credentialed at all times, end quote. Respondent described numerous corrective actions they have taken to prevent occurrences in the future. Based on the above, we'd recommend a civil penalty of $750, authorized via consent order, and formal hearing if necessary.
Thank you, sir. Any questions?
Yeah, this is Mr. Wheeler. I just have one for council. How did you come up with the $750 civil penalty?
Yes. So for 750, since this was a significant increase, this was 15 instances, a little bit of a higher civil penalty recommendation. Whenever I'm looking at these, I always check back at the disciplinary history to see if we have any recurring issues. And the only 2 instances of discipline that this establishment had was back in 2013, something not related to this, and 2010, also not related to this. To kind of compartmentalize with the previous one that was also 750 but had a lesser license period. In 2019, the previous establishment, again, just for clarity, the one in number 6, had received discipline for a manager of record serving in the capacity of a manager with with a expired license. So I would say on this one, 750 is due to the amount of unlicensed activity that occurred, and to kind of distinguish between the previous one that was for the same amount, though it was a lesser period, they had been disciplined for it before. So that was the basis for the recommendation.
Okay. Thank you, Troy.
Any further discussion or questions? If not, I will entertain a motion.
Mr. Haynes, motion to accept council's recommendation.
Tracy Allen, second.
Have a recommendation by Mr. Haynes, a motion by Mr. Haynes, and a second by Ms. Allen to accept council's recommendation, $750 civil penalty, authorized via consent order, and formal hearing if necessary. Ms. Bohannon, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
The motion passes.
Thank you, Ms. Bohannon. Number 8,
Number 8, complaint number 2025-057831. This case was administratively opened following a routine inspection conducted on September 24th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent is the employee identified in the preceding complaint who permitted their funeral director and embalmers licenses to expire on July 31st, 2025, and did not meet requirements to be reinstated until August 11th, 2025. And just as a reminder, during that unlicensed period, there were 15 separate instances of action or signature of documentation that required licensure. Respondent reiterated their response from the previous complaint, and based on the above, the recommendation is a $500 civil penalty, authorized via consent order and formal hearing if necessary.
thank you, sir. Any questions? If not, I'll entertain a motion.
I make a motion that we accept council recommendation, Wendell Naylor.
Second, Mr. Wheeler.
I have a motion by Mr. Naylor and a second by Mr. Wheeler to accept council's recommendation, $500 civil penalty, and authorize via consent order and formal hearing if necessary. Ms. Bohannon, would you call the roll, please?
Tim Wheeler,
Yes.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
The motion passes.
Thank you, Ms. Lisa. Number 9,
Number 9, complaint number 2025-063451. This case was administratively opened following a routine inspection conducted on October 21st, 2025. During the course of this routine inspection, the inspector observed the following. Upon arrival at respondent establishment, the inspector observed, quote, very tall grass in all areas surrounding the establishment. Directly in front of the steps leading to the front door of the establishment was a very large ant bed. There was a 3-body refrigeration unit in the yard adjacent to the side of the funeral establishment, and the refrigeration unit was not locked. In addition, the chapel area of the establishment was, quote, very cluttered, and the men's restroom, quote, was inoperable and in a very unsanitary condition, end quote. Respondent stated that all complaints have been addressed and corrected. Respondent sent legal roughly 30 photographs showing that the issues identified had been addressed. Respondent further stated that the outside cooler had been removed from the property as of November 20th, 2025. Based on the above, we'd recommend a civil penalty of $750, authorized via consent order, and formal hearing if necessary.
thank you, Mr. Bryan. Any questions? If not, I'll entertain a motion.
Mr. Wheeler makes a motion to accept council's recommendation.
Second, Wendell Naylor.
Have a motion by Mr. Wheeler and a second by Mr. Naylor. Accept council's recommendation, $750 civil penalty, authorized via consent order and formal hearing if necessary. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
The motion passes.
Thank you, Ms. Lisa. Number 10,
Number 10, complaint number 2025-045441. Complainant stated that they observed a hearse and other funeral vehicles parked in a parking lot of a local building that was not operating as a funeral establishment. Complainant also claimed that there were stretchers coming in and out of the building and theorized that the building was being used for preparation and storage of bodies. Complainant stated that renovation work was occurring on the building, but stated that they contacted the city and confirmed that no permits had been obtained. Complainant also alleged that the respondent location, which operates in a different city in Tennessee, but uses this new location as a satellite location without the board's knowledge. This case was not sent for a response, so that an investigator could make an unannounced stop to the location. On October 14th, 2025, the inspector traveled to the location. Coincidentally, the owner of the building was present and explained that he had purchased the property 2 years ago and was in the process of remodeling the building for a funeral establishment in the future. The owner stated they were planning to make an application to the board for a funeral establishment upon the project's completion. The owner stated they were a licensed funeral director and owner of respondent establishment. The investigator found no evidence of deceased human remains at the location, and the owner indicated that there had been no deceased human remains stored at this location since the property had been purchased. Likewise, the owner stated no family members of decedents had come to this location to make arrangements, make funeral payments, or make pre-need arrangements. The investigator photographed all portions of the building and found no evidence of any remains, nor any documents that would suggest that any type of arrangements had occurred. The investigator again returned unannounced on October 18, 2025, and did not witness any activity on the premises. The investigator also asked the owner to look in an adjacent building situated next to the identified location, which the owner stated it was an office used for administrative work. The owner stated it, too, was never used for funeral arrangements or funeral-related business at the building. Again, the investigator found no evidence that any funeral business had been conducted within either location. So based on the above, we would recommend closure.
Thank you, Mr. Bryant. Any questions? If not, I'll entertain a motion.
Mr. Haynes, motion to approve council's recommendation.
Second. Wendell Naylor.
Have a motion by Mr. Haynes and a second by Mr. Naylor to accept council's recommendation of closure of the complaint. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
The motion passes.
Thank you, Ms. Lisa. Number 11.
Number 11, complaint number 2025-051921. Complainant stated they were the manager of respondent establishment up and until September 3rd, 2025, when they were abruptly terminated by the owner of the establishment. Complainant alleged that the facility is currently being operated without any licensed personnel. Respondent replied, stating on September 3rd, 2025, at approximately 9 p.m., they received a text from complainant informing them they would not be present for work for the remainder of the week, with the knowledge that a graveside burial was scheduled for 2 p.m. the following day. Respondent stated complainant indicated that the absence was due to a disagreement regarding a decision involving a previous visitation. Respondent stated after being notified of complainant's absence, they contacted a different licensed funeral director to ask them to cover for the September 4, 2025 burial. Following that conversation, respondent also contacted a separate individual to inquire if they would be willing to take over as manager for complainant. Legal confirmed that payment for change of manager occurred on September 12, 2025, within the required 10-day period. Respondent stated that at no time did they ever operate without a licensed funeral director present to oversee operations or to have a licensed individual as manager of respondent establishment. Based on the above, the quote, abrupt termination of complainant is strictly a civil matter. If complainant believes that they were wrongly terminated, they may file a civil suit alleging the same. Such a determination is not within the board's jurisdiction. Likewise, complainant provides no evidence that respondent operated without a licensed individual, and their allegation appears to be based strictly on an assumption that in their absence due to termination, that no licensed funeral director was available to take their place. Respondent provided evidence to the contrary, indicating that a licensed director was available for the burial service the following day and implemented a new manager 8 days later. Based on the above, we would recommend closure.
Thank you, Mr. Bryant. Any questions? If not, I'll entertain a motion.
Mr. Wheeler makes a motion, we accept council's recommendation.
Second. Wendell Naylor.
Have a motion by Mr. Wheeler and a second by Mr. Naylor to accept council's recommendation of closure of the complaint. Ms. Lacey, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
The motion passes.
motion passes. Number 12.
Next complaint, complaint number 2025-053521. Complainant, daughter of the decedent, stated that their mother passed away on August 16, 2025. The following day, they arrived at the funeral establishment and gave her the information that would be on the death certificate to confirm that it was correct. Complainant stated that they didn't notice, but that the decedent's middle name was listed as the middle name as it had appeared on the decedent's birth certificate. Complainant stated that the decedent's legal name had been updated to have their maiden name as the middle name. Complainant stated they called and informed them of this on August 18, 2025, and let them know it should be corrected. Complainant stated on August 20th, the obituary was published where the middle name was listed as the death certificate middle name. Complainant stated they immediately called a respondent location and indicated it needed to be corrected. Complainant stated that on August 27th, they picked up the death certificates and went to establish an account for the decedent's estate and was told that the death certificate was incorrect. Complainant stated that respondent filed an affidavit with the state of Tennessee and it was received on September 9th, 2025, and that complainant was told by the state of Tennessee it would be an additional 10 to 20 business days until it would be corrected. Complainant stated they could not pay the decedent's bills in the meantime. Excuse me. Respondent replied, stating that they had several conversations with complainant regarding this matter. Respondent stated they explained to complainant that upon entering the decedent's maiden middle name and social security number into Verizon, there was not a match with an error that would prohibit them from submitting the death certificate for signature. When entering the decedent's name that matched the birth certificate, it was verifiable in Verizon and accepted. Respondent stated the decedent had made pre-arrangements with them back on March 6, 2025, and that she had given her name as the birth certificate name. Respondent stated that after the decedent passed away, complainant did not want the name listed as the birth certificate name and that she had dropped that name in 1965. However, respondent stated it appears that was never legally done and that the decedent started informally using the maiden middle name. Respondent stated they explained to complainant that they cannot use the maiden name on line 1 of a certified death certificate, but that complainant did not accept this explanation and asked for amendment, which was completed within 12 hours of the request. Respondent stated that complainant is frustrated that the state of Tennessee cannot make the change occur immediately. Respondent provided that they had done everything that complainant had asked and even met with her after hours twice in an effort to make things more convenient. Respondent also added that complainant signed every document that indicated the decedent's name as the birth certificate name and never made a comment until she realized that the decedent had multiple names that she had used throughout her life. Respondent even stated they had contacted the bank personally and made it possible for complainant to meet with the bank manager in hopes to assist with the banking matters. Respondent stated they could not think of anything more they could have done to assist complainant. Complainant provided a rebuttal stating that the decedent legally dropped their birth certificate name in 1965 and that legal documentation had reflected the maiden middle name for decades. Complainant attached legal documents, driver's license, insurance cards, social security card, etc., that indicated the maiden middle name. Complainant stated that they did not request one name over another, only that the death certificate accurately reflected the decedent's legal name. Complainant indicated that they received a corrected death certificate on September 24th, 2025. Based on the above, it is unclear regarding the status of the decedent's legal name. While complainant provides legal documentation suggesting the maiden middle name is the correct legal name, respondent describes issues with Verizon matching the maiden middle name with the social security number. To further complicate this question, complainant also attached a copy of the pre-need contract where the decedent signed their name with the birth certificate middle name. Respondent appeared to have done everything in their power to assist complainant and submitted an amendment for the middle name when the possible error was brought to their attention. So based on the above, we'd recommend closure.
Thank you, Mr. Bryant. Any questions? If not, I'll entertain a motion.
Mr. Haynes, motion to approve council's recommendation.
Tracy Allen, second.
Have a motion by Mr. Haynes and a second by Ms. Allen to accept council's recommendation of closure. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
The motion passes.
thank you. Number 13,
Hold on just a moment. I need to recuse myself on the next case, please.
okay. Mr. Wheeler will be recusing himself for number 13 on the complaint report.
All right, number 13, complaint number 2025-054471. Complainant was formerly employed by Respondent Establishment as an apprentice funeral director and embalmer from March 1st, 2023 to March 20th, 2024. Complainant stated the owner of Respondent Establishment was listed as the sponsor on the quarterly reports. Complainant stated that the owner signed favorable quarterly reports for the second, third, and fourth quarters of 2023, and that they mutually agreed to part ways in March of 2024. On April 13th, 2024, complainant contacted the owner's daughter, asking when a good time would be to sign the apprentice paperwork for the first quarter of 2024. Complainant contends this text was ignored and that they sent a follow-up text on April 15th that the daughter communicated with. Ultimately, the daughter stated that a hard copy was being sent via mail, and a copy was also available at the funeral home. Complainant stated they requested a DocuSign version, but were told by the daughter that the report had to be notarized, so it needed to be signed in person. Complainant stated they told the daughter, quote, "I'll take it from here." Complainant stated the envelope containing the apprentice paperwork never arrived. Complainant stated she gave the situation time, hoping that it would, quote, "heal this divide." And on July 28th, 2024, complainant contacted the owner's wife asking if they could set up a meeting with the owner to sign the paperwork. Complainant stated the text was read but not responded to. Complainant emailed the daughter on August 11th, 2024, requesting a meeting to meet with the owner to sign the paperwork. Complainant stated the daughter responded, stating that she should contact the state because the owner's health had deteriorated to where he could not recall complainant's role or who they were. Complainant then makes allegations that the daughter, who is not a licensed funeral director, routinely commits unlicensed activity, but provided no evidence to support this assertion. The daughter responded on behalf of Respondent Establishment, stating that after complainant's termination, they contacted them via text regarding the quarterly reports. Respondent explained that in April 2024, their father's health declined rapidly, resulting in a hospital stay. The daughter also stated that around this time they were out of the state and that, quote, "facilitating the signature for her reports was not our family's main priority. Our focus was on my father's health," end quote. Respondent stated, quote, "After several days of not responding to complainant's repeated messages, she escalated the situation by sending a text message threatening to report us to the state board if her request was not addressed," end quote. The daughter stated that day she showed her father the text, who asked that she print the report and give it to him the next day so he could sign it. The daughter stated she then directed an employee to overnight it to the state board and text complainant stating the same and that the issue was resolved. However, the daughter stated they returned to realize that her father had not signed the report because complainant had filled out sections meant for the owner and used an electronic signature. The owner stated he would only sign the document in person because it needed to be notarized. The daughter relayed this information to complainant and asked her to call regarding future matters. The daughter stated that the next contact she received was a month later from the state board that included a communication from complainant stating she did not feel comfortable coming to Respondent Establishment. From May 2024 until July 2025, there was no further contact. In July 2025, complainant again contacted them requesting a meeting with the owner to sign the quarterly report. The daughter stated at this time her father was not mentally capable of completing or signing the report and was often confined to a bed or a recliner at his home. Respondent stated complainant was aware of his declining condition and dementia prior to her termination, and that it was her responsibility to bring the report to the owner in a timely manner, and that the owner had previously agreed to sign the report if it was presented in person, but that complainant did not follow through. Based on the above, we'd recommend closure.
Thank you, Mr. Brunt. Any questions? None heard. I'll entertain a motion.
Tracy
Make a motion
Allen.
that we accept council recommendation, Wendell Naylor.
Tracy
Ms.
Allen.
Allen, there you go. Would you like second?
Yeah.
All right. We have a motion by Mr. Naylor, second by Ms. Allen to accept council's recommendation of closure. Ms. Bohannon, would you call the roll, please?
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
The motion passes.
thank you. Mr. Wheeler, are you back on?
Can you hear me?
I've got you. Thank you very much, sir. Number 14.
Next complaint, complaint number 2025-060221. Complainant stated that Respondent Establishment failed to give them proper information regarding the cemetery's rules for the decedent's headstone. Complainant stated that the cemetery is planning to remove the headstone for violating cemetery rules and requirements. Complainant alleges unprofessional conduct that Respondent Funeral Establishment failed to communicate these rules requirements to them. Respondent replied, stating that they fulfilled all services outlined in their agreement, including coordination with the cemetery for burial. Respondent stated that cemetery requirements, such as those regarding headstone specifications, are independently managed by the cemetery and falls outside their scope of service. Respondent stated it was their understanding that complainant had purchased their marker through Amazon and that complainant did not inform them that they were anticipating buying a headstone without clearing the requirements with the cemetery first. As a rebuttal, complainant attached a copy of communication from the cemetery that states specifically, quote, "We sell many types of monuments and hope that you will purchase one from us. But if you purchase elsewhere, please have your monument company ask for a copy of our monument policy, which describes our requirements. Monuments that do not meet our requirements will be removed and held for 90 days. Monuments may not be installed by individuals," end quote. However, interestingly, the sheet that contained this disclaimer was signed by a representative of the funeral home, not by complainant. While complainant filed a similar complaint against the cemetery stating that they had failed to make them aware of the cemetery requirements, the cemetery provided ample evidence to show that complainant had been made aware of the marker requirements via conspicuously posted notices in the cemetery office. Based on the above, ordinarily, respondent would not have an obligation to inform complainant of the marker requirements in the cemetery. However, with a representative signing the disclaimer sheet, which was intended for the complainant, in legal's opinion, respondent adopted that responsibility and the requirement to inform complainant was transferred to them. From legal's view, it was complainant's duty to know, or they should have known, of the cemetery requirements before taking it upon themselves to purchase a marker from Amazon and installing it themselves without clearing it with the cemetery. However, respondent also adopted the responsibility to inform complainant of those cemetery requirements when signing the disclaimer sheet. So based on the above, we would recommend a letter of warning.
Questions? If not, I'll entertain a motion.
Don Haynes, motion to accept council's recommendation for letter of warning.
Second by Wendell Naylor.
I have a motion by Mr. Haynes and a second by Mr. Naylor to accept council's recommendation for a letter of warning. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor, Chris Lee.
Yes.
The motion passes.
Thank you, Ms. Lisa. Number 15.
Next complaint, complaint number 2025-061121. Complainant submitted what amounts to an anonymous complaint by erroneously providing the information of an individual who works at respondent establishment as the complainant, alleging that respondent establishment refused to provide them copies of the decedent's files since they were not listed as the next of kin, even though respondent allegedly knew the individual was the decedent's daughter. Would-be complainant stated that they showed respondent copies of administrator letters from the courts and claimed that they were told that employee listed as complainant would be in touch. Would-be complainant stated it had been months and respondent had not replied. Respondent replied, stating on February 11th, 2025, they were contacted for removal of the decedent and were informed by the medical center that the person of contact was the sister of the decedent. The sister scheduled an arrangement conference for 10 a.m. on February 12th. The sister brought an individual with her who she introduced as the husband of the decedent. The two provided all the vital information, and the husband of the decedent signed the cremation authorization form, identifying him as the authorizing agent and allowing the sister to receive the remains after cremation occurred. The sister's daughter paid for the funeral bill in full. On February 13th at 1:50 a.m. Eastern Time, respondent received a call from, who is presumably, the complainant, asking why she had not been contacted about their mother's passing, as she was the next of kin. The funeral director on call attempted to call them back, but received no answer. Thus, the funeral director put a hold on the case and on the cremation as they wished to verify they had the proper next of kin on file. On February 14th, the daughter spoke with two funeral directors and claimed that the decedent and the husband were divorced and that there were two additional children in addition to her. The daughter stated she was fine with cremation but wanted a copy of the death certificate. The two directors called the husband to inform him of the claim, and the husband confirmed they were married at the time of the decedent's death and supplied a copy of the marriage certificate, which was attached to respondent's reply. When the husband provided the death certificate, he specifically stated that he did not want anyone to receive information or documentation besides himself and the decedent's sister. Respondent then called the county clerk to check and see if a divorce decree was ever filed. The court clerk indicated that there was no divorce decree and that the husband was still legally married to the decedent at the time of her death. Thus, an update was made to the case management system indicating that no information could be shared with the decedent's children at the request of the decedent's husband, the next of kin. The directors then called the daughter to let her know that the husband was the verified next of kin. It was told that she could go to the local health department to request a death certificate if one was needed. On February 15th, the daughter emailed the director expressing doubts about the marriage. When the director stated it had been confirmed by the courts and they were required to follow the husband's wishes. On February 24th, the remains and copies of the death certificate were released to the husband and sister. On February 26th, the daughter emailed the director again, asking for information involving the death certificate, and the director did not respond. This was the last time they heard from the daughter until July 21st. The daughter again spoke with one of the directors, stating that she thought, quote, something sinister happened to her mom and that she got appointed and that she was going to get her doctors and things to get info, end quote. The daughter continued stating the sister had lied on the paperwork and that the children wanted copies of everything for peace of mind. The daughter called again on July 22nd, stating that she had been appointed executor of the estate and that she wanted a copy of everything in the funeral file, adding again that the sister of the decedent had lied. The director advised that they were not permitted to release information to anyone who is not the next of kin, to which the daughter stated that she was the next of kin. The daughter concluded by stating she would have her lawyer call them because she needed a copy of everything. Respondent stated they have received no contact from an attorney in any form and that there have been no calls or communications from the husband of the decedent granting permission to release any information or documentation. Complainant stated in a rebuttal that while the decedent was legally married to the husband at the time of passing, quote, they were living separately and estranged, end quote. Complainant then argued that 62-5-703 follows the right of disposition as follows, quote, 1, the surviving spouse, if legally married and not estranged or living apart. 2, the surviving adult children, end quote, and purports that this proves that she and the other surviving children should be the next of kin. Based on the above, the latter portion of the clause that complainant purports proves the matter is incorrect. 62-5-703 does not carve out an exception for a legally married couple if the couple is, quote, estranged or living apart, end quote. It is unclear where complainant contends this latter clause comes from, but in reviewing the statute, that exception simply does not exist. Respondent appears to have gone above and beyond in confirming that the husband and decedent were still legally married at the time of the decedent's death. Upon confirming as such, respondent followed the next of kin's instruction that no information or documentation be shared with anyone else other than themselves and the sister of the decedent. Respondent followed this instruction. If a valid basis exists for complainant to obtain the funeral documentation information as executor of the estate, that would be for a court of competent jurisdiction to determine, not this board. Without a court order, respondent is bound to abide by the wishes of the designated kin, which they have. Based on the above, we'd recommend closure.
Thank you, Mr. Bryant. Any questions? If not, I'll entertain a motion.
Mr. Wheeler makes a motion to accept council's recommendation.
Don Haynes, second.
I have a motion by Mr. Wheeler and a second by Mr. Haynes to accept council's recommendation of closure. Ms. Bohannon, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes,
The motion passes.
thank you. Number 16.
16, complaint number 2025-061801. Complainant stated that their son passed away in July 2022, and despite multiple attempts to contact respondent's office, they have not received the death certificate. Complainant stated they have been unable to complete important legal and personal processes. Respondent replied, stating that they called the complainant and apologized that they were not aware that she had not received her son's death certificate and that they would contact the health department and pick them up. Respondent apologized for the delay and inquired as to whether complainant would want to pick them up or have them mailed. Complainant confirmed they wanted them mailed, and respondent sent them via certified mail and called to ensure that complainant received them, which complainant indicated she had. Legal spoke to the complainant on the phone and confirmed that she had received the death certificate. However, complainant indicated that though they had received communication from respondent following the filing of this complaint, they did not receive any communication in all of the preceding time. Legal also contacted the Department of Health to determine the timeline of this death certificate. On July 12th, 2022, the record was created. On July 14th, 2022, it was assigned to respondent. On July 15th, the case was certified. On July 19th, 2022, the case was released. On April 27th, 2023, delayed diagnosis was added. And April 27th, 2023, the death certificate was signed by the certifier. Based on this timeline, it does appear there was a significant delay in the diagnosis and certification by the medical examiner. However, this still only gets respondent to late April 2023. It does not appear that respondent maintained any form of contact with the complainant, updating them, informing them of the delay, etc. during that time. Based on the above, we'd recommend a $1,000 civil penalty, authorized via consent order, and formal hearing if necessary.
Thank you. Any questions? If not, I'll entertain a motion.
Don Haynes, motion to approve council's recommendation.
Mr. Wheeler, second.
Thank you. Mr. Haynes has made the motion. Mr. Wheeler, second. $1,000 civil penalty and authorized via consent order and formal hearing if necessary. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen. Tracy Allen,
Sorry, yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
The motion passes.
Thank you. Number 17.
17, complaint number 2025-064-121. Complainant stated that their mother passed away on May 15th, 2025, and was placed in the care of respondent for cremation services. Complainant stated the respondent gave repeated excuses as to why the cremation was delayed, with that the decedent was finally ready for pickup on June 6th. When complainant received the documents, they advised the respondent that the name and address were wrong on the death certificate and the address was wrong on the cremation certificate. Complainant stated respondent indicated they would get those corrected, but despite allegedly contacting respondent for months, they'd yet to receive the amended documents. After a conversation with legal, respondent contacted Vital Records on November 18th, 2025 regarding the death certificate amendment. In an email to legal, respondent stated only, quote, "I think I now know why this was not amended," end quote, but did not elaborate further. Respondent indicated that it would be overnighted tomorrow, November 19th, 2025, and indicated that they should receive it on November 20th, 2025. In this response, respondent indicated they would provide to legal proof that it had been overnighted to Vital Records. At this time, legal did not receive this information. After a call again to respondent on December 1, 2025, respondent stated they're not entirely sure why the death certificate amendment was not received because it was sent. Respondent theorized that they had sent it to the wrong address and thus not properly received, but couldn't say that for certain. Respondent indicated in this conversation, again, that they would send legal proof that it had been overnighted on the 19th of November. Having not heard from respondent, legal again contacted respondent on December 3rd, 2025. Respondent explained that they had not yet sent the amendment for the death certificate, but claimed that it would be overnighted that day and claimed that they would provide proof it was overnighted. Respondent did not elaborate why it had not been overnighted on November 19th, 2025, as they had originally stated. And as of today, December 9th, 2025, I have not received any information to indicate that it has been overnighted. Based on the above, we would recommend a $1,000 civil penalty, authorized via consent order and formal hearing if necessary.
Thank you, sir. Any questions? If not, the chair will entertain a motion.
Mr. Wheeler makes a motion to accept council's recommendation.
Tracy Allen, second.
Have a motion by Mr. Wheeler and a second by Ms. Allen to accept council's recommendation, $1,000 civil penalty, authorized via consent order and formal hearing if necessary. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
The motion passes.
Thank you. Number 18,
Number 18, complaint number 2025-062871. I will preface this one with saying this is a long one and a unique situation. So if you have any questions as we're going through it, or if I lose you, please just let me know and we'll try and parse through it. On July 30th, 2025, a pre-need auditor with the department conducted a routine pre-need audit of respondent establishment. During the course of the audit, the auditor found that for one contract, cash advance items had been paid as honorariums. It was discovered that a decedent had passed away on April 14th, 2022, and was a resident of an assisted living facility. The contract was entered into in July 2022, 98 days after the decedent had passed. Due to the decedent's passing, the decedent was not an insurable entity, and so the funds were deposited into a trust account. The decedent had donated their body to science due to having no family. The cremated remains were ultimately returned to the assisted living facility sometime in 2024. The staff at the facility contacted respondent to set up services for late June 26, 2024, in order to extinguish the trust funds. Per respondent management, they sold an urn, niche plaque, niche vase, niche memorial service, and cemetery equipment setup. However, the two nursing home staff members required that the minister, who appears to be related to the two nursing home staff members, and the service participants, the two nursing home staff members themselves, be paid with the remaining funds. It was noted that the final bill signed by the two staff members was a line item for Flores Geraldines for $1,000. However, per conversation with the respondent, the staff member decided not to use the flowers, and those funds were split three ways. The remaining funds were split three ways between the minister, speaker, one of the staff members, and musician, the other staff member. Respondent divided the remaining excess funds and issued them a cash advance honorariums for the minister and service participants. Checks were issued to the minister, speaker, and musician in the amount of $1,956.35, $1,956.35, and $1,956.36, respectively. Respondent was unable to provide documentation to show that the decedent had authorized these payments to the three individuals. Respondent replied stating that they were approached by the facility case manager, the speaker, who said that the decedent had died earlier in the year and that they needed to clear her residential account funds to close out their fiscal year end. The speaker stated it was their intent to spend all of the balance on funeral expenses. Respondent stated after discussing with the director that since the decedent would be cremated at the expense of the medical donation coordinator, they could not reasonably sell them nearly $9,000 in goods or services. After discussion, it was decided to include a cemetery niche, plaque, and urn, and provide a graveside service with cemetery equipment for approximately $3,400. The speaker explained that the balance could not go back to the facility, so respondent proposed the idea to divide the balance into cash advance to go to the service participants, and that the money could be donated toward resident activities or other ways in which the decedent could support other residents of the facility. Thus, ultimately, the three checks were written directly to the minister, speaker, and musician. This appears to be a highly unique situation. In short, the decedent had excess funds in their pre-need trust that respondent did not feel comfortable charging for the entirety of, particularly for a decedent who had already been cremated. What was ultimately done, after the $3,400 was charged for the funeral services, is that the remainder went to three individuals without any authorization or way to verify that the funds were indeed going to support other residents of the facility. While legal cannot say this with complete certainty, legal feels obliged to share with the board that after a brief Google search, an obituary from a few years ago lists the name of the minister, the speaker as the daughter of the minister, and the first name of an individual matching the name of a musician as another daughter of the minister, suggesting that this was musician's maiden name. The evidence suggests, but does not prove, that the three cash advance participants were all related. It appearing to legal that respondent attempted to do the right thing, particularly at their decline to find charges to equal $9,000 so that they may have the full value of the pre-need funds. However, no documentation from the decedent authorized those funds going to three individuals under the basis of cash advance items, particularly without verification that it would go back to the assisted living facility, as was evidently the stated plan. Furthermore, this concern is further exacerbated by the fact that the speaker chose to cancel the $1,000 flower arrangements. Legal would suggest to the board that respondent had an obligation to, at the very least, ask additional questions and implement reasonable safeguards to ensure that these three individuals did not receive the decedent's funds that did not belong to them. While respondent indicates that many discussions occurred internally, they provide no proof to ensure that the funds would indeed go to the facility as was intended, or that detailed questions were posed to the cash advance participants to ensure that this was indeed endorsed by the facility. Likewise, indisputably, respondent wrote a pre-need contract 98 days after the decedent had already died. Notably, respondent states in their reply, quote, "I do not know what the final disposition of any funds was after we provided the refund check to the service participants. In hindsight, this should have been handled differently, but we were acting in what we thought was the most reasonable manner," end quote. Legal would suggest to this board that failure to implement those safeguards or take steps to ensure that the cash advance funds would go back to the facility as planned is a violation of professional conduct, and that respondent should receive a letter of warning.
Thank you, Mr. Bryant. Any questions, comments?
Mr. Wheeler has several questions. Is it not a violation of Tennessee annotated code to write a pre-need contract after the fact that the death has occurred?
Yes, it is.
Okay, so I guess my question is on that, is that not something we should be addressing, that technically they broke the law by issuing a pre-need contract on someone who was, gosh, going on over 3 months, who'd passed away?
Yes. So I'll explain the recommendation of letter of warning a little bit. I think, and two, since this is a unique and confusing situation, it made sense to start here. And if the board had concerns and would like to increase that to a civil penalty, I have zero objections whatsoever. I think what, I'm not going to say helps them, but I think with no disciplinary history and with a highly unique situation where it seems like they're doing their best to navigate it as well as they can. Respondent even admits, in hindsight, they should have done something differently. But I agree, those two things seem to work in their favor, that they tried to do the right thing. They basically could have come up with charges to equal $9,000. They didn't. It's a unique situation, and they seem to try and be approaching it the best way they can. What cuts against them is the professional conduct issues that I alluded to of not asking questions or putting in safeguards. And I think, as I referenced to, the unequivocal, indisputable fact that they wrote a contract 98 days after the decedent had already passed away, which is a violation, I think, in black and white. So I landed a letter of warning knowing that the board would probably have questions and concerns and may want to go higher. And as I said, I have zero objection to that whatsoever.
Okay, thank you, Mr. Bryant. But I guess my next part I go to is the amount these three individuals were paid for their services. I mean, that's exorbitant. To me, that just I feel, and the funeral home should have picked up. There's no proof that any of this was money other than going in these three individuals' pockets. And gosh, I'll speak at a funeral for that price. I'm not sure they'll get what they want, but to me, it looks like this family, because they're all peer kin to each other, they all padded their pockets with a dead person, a decedent's funds, which I find extremely unethical, both on the funeral home's part and these three individuals. But my main concern is the law was broken writing a pre-need contract. They should have never have taken the money. That contract should have been moved into an at-need contract, not a pre-need, but an at-need. And I think any licensed director would know that is the steps you should take.
And on top of that, Mr. Whaler, even the fact of canceling at least $1,000 worth of flowers that she requested, I definitely have 100% hard time with this letter of warning or warning of any kind, but I really don't know what the proper step or amount would be or where we need to go with this.
So I guess I would look to counsel Mr. Bryan on that. What would, because we have a serious violation of Tennessee code. And it was a sizable amount of money. And then the 3 checks, you know, as a licensed director, I would say, whoa, wait just a minute. Because just like Mr. Leah said, there was $1,000 and all of a sudden that money is no longer going to be used on flowers, which would have benefited that decedent's service. That would have been that person's money for their own service. I have no problems with that. $1,000 is a lot of flowers in my book, but to me, my main thing is a pre-need was written when it should have never been written. It should have been an at-need contract. And a licensed director, an owner of a funeral home, they should know this is the law and you cannot write a pre-need contract on someone who's already deceased. So I feel there needs to be a civil penalty. And I'm open to suggestions from council. I'm open to suggestions from other board members.
Mr. Wendell, I agree with you. If nothing else, they, could return the money back to the nursing facility and just let them deal with it. That's, and again, I'm like you. I'll speak at the funeral for that type of money. And I mean, out of the 40-some years, I've never paid a minister anything like that, and just using that money like that, I don't think it's, it's right. And I think, it did just go in their, in their pockets, because unless they can show us some proof that they did something at the nurse's facility for the other residents or something like that. But I agree. I don't think it should be a letter of a warning. Some penalty should be put to this. I do see where, they have not done anything, before, but this is kind of like can you tell us how old is this establishment?
Mr. Gribble, do you have any information on that point?
I did not completely hear the question. Was it how old is the establishment? How long has it
Yes,
been in
sir.
business?
How long they been in business?
It's a seasoned establishment. It was a seasoned funeral director. I can tell you in just a minute about how long it's been licensed for 30 or more years at least. Just a second. I'll be glad to look and see.
And I agree with you, Mr. Naylor, on this. And I think all of us in funeral services, licensed personnel, we've all dealt with nursing homes where patients have excess funds. They've got to keep it below so that they still are qualified for Medicare and all that. So the funeral home should not become the holder of just funds, on that, and the money should have went back to the nursing home, and that should have been their problem to deal with what to do with the money, especially if the patient was on TennCare or Medicaid. That money, if there's excess funds that can't be used, it goes back to those usually, which, is good. But to me, if they are a seasoned director and a seasoned funeral establishment, they should know better than to break the law. And that's what this is just a pure violation of the Tennessee code.
To answer your question, Mr. Naylor, the funeral establishment, according to our information in court, was licensed in 1971, and the individual funeral director in this particular case was licensed April 24, 2002.
Thank you, Mr. Gribble.
So I think if the board just wants some general information, not necessarily a suggestion, that's up to you all, but so I think we have column A, which is violation for writing a pre-need 98 days after the time of death. That's black and white. I don't think that's disputable. That violation, I would say, can go up to, since it's one instance, one day, kind of the act of writing it was the violation, I think your cap there is $1,000. Likewise, column B, you have kind of the professional conduct concerns of writing these cash advance for almost $2,000 for each for these three participants. I would say it's tricky because I think an argument could exist that those are three separate violations of doing that. But I think to be safest to not overstep the bound, I would recommend that the cap there be $1,000 as well for the overarching act of just the unprofessional conduct of basically, as Mr. Wheeler and Mr. Naylor have already stated, basically taking that money out of the pre-need and kind of putting it into three people's pockets. From what respondent says, the intent was good. No way to verify what the actual intent was, but what they're claiming, but put no safeguards or any mechanisms to ensure that's what was actually occurring to go back to the facility. So I would say your ceiling that makes me feel comfortable is 2,000, and obviously what defer to you all, whatever you think would be most appropriate.
I mean, my big thing here is there never should have been a pre-need. That money never should have left the funeral home, or either if they were going to buy the niche and have a memorial service, that amount only be allotted at an at-need. So this money should have never left the funeral. I mean, at the nursing home, in my opinion.
And I agree with Mr. Lee. And with that, I'll make the recommendation that we assess a civil penalty of $1,500. That's a little bit below what council says our cap can be on each of these of $1,000. That'd be $750 each for a total of $1,500.
Second, Wendell Naylor.
We have a motion by Mr. Wheeler and a second by Mr. Naylor for a $1,500 civil penalty via consent order and approval for hearing if necessary in lieu of the letter of warning. Ms. Bohannon, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
Motion pass.
Thank you, ma'am. Number 19.
And just to clarify on that last one, Mr. Lee, I think you got it, but just wanted to make sure that that was for authorization for consent order and formal hearing if necessary.
Yes, I thought I stated that, but absolutely, Mr. Bryant. Thank you.
Okay, thank you. And last one is complaint number 2024-062531. This is another long one, so stick with me if you have any questions. I hope I make it as narrowed down as possible at the end, but any questions, please just let me know. Complainant stated that their mother arrived at respondent establishment at 1:19 a.m. on November 1st, 2024, a Friday morning, and was placed in a temperature-controlled room, not refrigeration, until November 4th, 2024. Complainant stated that respondent was made aware that the decedent was Jewish, and per Jewish custom would not be embalming the decedent. Complainant alleged that the decedent's body began to decompose significantly due to not being stored in the refrigeration cooler, and due to the decomposition, the decedent was unable to have a proper Jewish burial and was placed in a biobag on November 4th, 2024. Complainant also alleged that respondent had, quote, fraudulently overcharged for services provided. Respondent replied through counsel stating that the decedent had passed away on October 31st, 2024, and upon arrival, quote, the skin on the right side of her face was purposed with discoloration due to blood settling, end quote. Following treatment, the decedent was placed in respondent's care center, which contextually appears to be the prep room. Respondent stated that the husband of the decedent, one son and one daughter, were present for the arrangement conference, but that complainant was not present. The decedent had left instructions for her disposition, which were 1, she was not to be embalmed, 2, she was to have a plastic burial vault, and 3, she was to be buried in a specific space already owned by the family. Respondent stated neither the decedent nor decedent's husband had any other religious-based instructions, but respondent secured the name of an appropriate rabbi to ensure that all religious practices were followed. On November 5th, 2024, the decedent's children, including complainant, came to respondent establishment to express their discontent over the services, but that decedent's husband, the next of kin, never complained. However, respondent stated due to the persistent complaints from the decedent's children, all funeral services, merchandise, and burial services were provided to the decedent's husband free of charge and provided a courtesy discount of $2,189 for the companion memorial. Complainant provided a rebuttal stating in part that their father, husband of the deceased, had not been made aware of the issues the family had had due to his health and age, and that they had intentionally shielded him from knowledge of their concerns. This case was sent for investigation. Complainant largely reiterated what they had stated in their complaint, providing specifically that it appeared the decedent was not placed in refrigeration until November 4th, 2024. Complainant claimed when staff was asked why the decedent was not placed in refrigeration prior, they were told that decedents are placed in the care center while they wait to schedule the family to discuss arrangements. The arrangement conference occurred on November 1st, 2024. However, the decedent ultimately was not moved to refrigeration storage until November 4th, 2024, resulting in the decedent being in the care center for 4 days prior to being moved to refrigeration storage. The investigator also spoke to the employee of respondent establishment who had made the arrangements with the decedent's family. The employee stated that they met with the family on November 1st, 2024, and that a graveside service was scheduled for November 6th, 2024. The employee stated that after the employee, arrived at the funeral home at approximately 7:45 a.m. on Monday, November 4th, 2024, and discovered that the decedent had some discoloration and purging. The employee contacted the rabbi to confirm that a bioseal container would be appropriate for Jewish ceremony, and the rabbi confirmed that it would be. The decedent was then placed in a bioseal container and put into refrigeration. Soon after, the employee had a discussion with one of the children of the decedent, who stated that a licensed funeral director and embalmer would be accompanying the rabbi to assist in performing the Jewish ceremony in the preparation room. However, per company policy and for liability concerns, the funeral director and embalmer, who is not an employee of respondent establishment, was not allowed in the prep room. Following this, on November 5th, 2024, the 3 children met with the employee and expressed their dissatisfaction. As a result, the employee asked the manager of respondent establishment to speak with them. The investigator asked the employee why the decedent's body was not placed in refrigeration when brought to the funeral home on Saturday morning, and the employee replied that they were unsure. Next, the investigator spoke with the manager of respondent establishment, who described the timeline as follows. Funeral home employees made the removal of the decedent from her home on October 31st, 2024, and that the body was brought directly to the funeral home and arrived at 1:19 a.m. on November 1st, 2024, and was placed in a temperature-controlled care center. The care center was approximately 60 degrees. Next, the employee made funeral arrangements with the family on November 1st, 2024. On November 5th, 2024, the manager met with the decedent's children and did her best to address the concerns of the family, including stating that per company policy, a separately licensed funeral director and embalmer is not permitted to enter the care center or prep rooms, but that they could be allowed to assist the rabbi in one of the adjoining rooms to perform the requested Jewish rituals, and that the manager asked several times what else could be done to satisfy their displeasure with the services. Ultimately, respondent agreed to waive all service and merchandise charges, not as an admission of guilt, but in an effort to provide customer service to a family who is displeased with their services. The investigator inquired as to why the decedent was not placed into refrigeration upon arrival, and that the manager stated they were not sure, but that there had been some miscommunication with the funeral home staff. The investigator also obtained the funeral file, which included a letter from the embalmer dated November 6, 2024. The letter describes the decedent as coming in on a cot and sheet, quote, covered in brownish red coloring from blood and purging from her nose and mouth, and the blood had settled on her, and her face on the right side was completely purple with discoloration. On November 6, 2024, I took her out of the cooler and opened BioSeal bag. Her face was still discolored and still purging from her mouth and nose. From her chest down, there was slight discoloration. Her ankles and feet had no discoloration. I sealed her back up in a new BioSeal bag and put her in the casket. Based on the above, there appears to be 3 allegations from complainant. 1, respondent did not abide by proper Jewish tradition. Based on the information provided, it appears respondent did everything in their power to properly research proper Jewish burial tradition and contacted a rabbi to assist in this endeavor. Omitted from the summary are several steps respondent underwent in order to confirm everything was proper for Jewish custom and worked closely with the rabbi, even when Jewish custom at times conflicted with company policy, as it did when the funeral director and embalmer sought to enter the preparation room with the rabbi. Respondent attempted to work around this as best as possible so as not to disturb their corporate set policies, but also so that the proper Jewish practices could be followed. One specific complaint introduced from complainant is that due to the use of the biobag, the decedent was unable to use the shroud, one part of the traditional Jewish ceremony. The manager of respondent establishment provided that it had been obtained and provided to the rabbi, and the licensed funeral director and embalmer assisting the rabbi, but that it was not used in the ritual. Based on the information obtained, it is uncertain if this was due to the use of the biobag or was not used for another reason. It would be my recommendation to the board to not fine for violation on this allegation. 2, respondent fraudulently overcharged for services provided. Complainant does not provide specific proof of this allegation other than to say that there was a charge for the dressing and cosmetizing of the deceased, that the employee was, quote, very pushy, end quote, when it came to hair and makeup services when they were against Jewish tradition. Notably, when the investigator met with complainant did not mention or provide any additional information regarding this allegation. Likewise, respondent refunded all funds associated with the funeral and burial services and merchandise. It would be my recommendation to the board to not fine for violation on this allegation. 3, respondent violated professional standards when failing to refrigerate the decedent. Based on the timeline, the decedent came into respondent's care late October 31st, 2024, Thursday, or very early Friday morning, arriving at respondent establishment at approximately 1:19 a.m. on November 1st, 2024. The decedent was placed in a temperature-controlled room, which again appears based on the contextual information to be the prep room, set at 60 degrees. Based on the evidence obtained, it appears that it is custom practice of respondent establishment to keep decedents here while next steps are being determined through the arrangement process. An employee met with the family of the decedent, without complainant present, for the arrangement conference. Respondent's removal staff learned of the decedent's Jewish customs upon transport on October 31st, 2024, and the employee learned of it at this conference the following day. Key among this information was that per Jewish custom and tradition, the decedent was not to be embalmed, which was, at the very latest, communicated to respondent at the arrangement conference. Per the timeline provided, it appears that the graveside funeral service was set for Wednesday, November 6, 2024. Per the employee, on Monday, November 4th, 2024, at approximately 7:45 a.m., the employee discovered discoloration and purging from the decedent, cleared it with the rabbi that a bioseal container was appropriate per Jewish custom, and then placed the decedent in the refrigeration unit. In short, the decedent was in respondent's care for approximately 78 hours and 25 minutes before being moved to the refrigeration unit with the knowledge that the decedent could not be embalmed per the family's wishes and per Jewish custom. During this period, the decedent was kept in respondent's care center, which was a temperature-controlled room of approximately 60 degrees. Tennessee does not have a law that specifies a decedent must be placed in refrigeration within a specific time frame or placed in refrigeration at all. However, it appears to legal that this is the particular rule at play. Rule 0660-11-.05J states, funeral directors, embalmers, and establishments shall conduct themselves in a way that does not offend the reasonable sensibilities of the public and reflects respect for dead human bodies. My recommendation to the board is that the board discuss on the record whether the facts as we understand them suggests whether respondent placing a decedent who could not be embalmed in a care center temperature-controlled 60-degree room for roughly 78 hours and 25 minutes before being placed in refrigeration, whether that is a violation of the stated professional conduct rule. To clarify, there can be no violation specifically for failing to place a decedent within a refrigeration unit within a certain time frame, as no law or rule exists. However, the underlying conduct of not doing so within a particular time period based on the context and circumstances may still violate applicable professional conduct standards if determined by the board. So that is the question I laid to all of you after that essay.
Thank you, Mr. Bryant. Any questions or comments or discussion? this may be the question in the room, Mr. Bryant. I mean, I'm thinking if you've got a cooler, why not use it? But then again, there's no law that they violated according to legal. I hate to ask you to kind of step out some more on this, but we definitely don't want to do something outside our realm. But I guess I don't understand the first part of my question.
Sure. Hopefully, I can help clear that up a little bit. So, if I would advise against the board coming away with the determination that respondent violated because they did not. There's some rule out there or law or that says a decedent has to be put in refrigeration. They do not. There's no time period that states that. There's no law that states they must do that. But I think the underlying question is, I think that path is a red herring. That's a distraction. The question in front of the board is that rule is what's at play. Funeral directors, embalmers, and establishments shall conduct themselves in a way that does not offend the reasonable sensibilities of the public and reflects respect for dead human bodies. That is something that, per the board's determination, maybe the respondent did violate or maybe they did not. That question comes down to, I think the key here is, one, they know they can't embalm the decedent because of Jewish custom and tradition. So the decedent is left in the 60-degree prep room, or the care center as they call it, for 78 hours and 25 minutes. Is that failure to move the decedent to the refrigeration unit, again, not a violation of some law that says they have to do that, but does that fall under the reasonable sensibilities of the public? Again, it can't be a violation of a law that doesn't exist regarding the refrigeration, but it could, if the board so determines, be a violation of professional conduct standards regarding the reasonable sensibilities of the public. So to me, there's a lot of moving parts here, but I think as simply as I can put it, just of what the board should focus on. Can't embalm the decedent. They're in a temperature-controlled 60-degree room. It's 78 hours and 25 minutes before they're removed to refrigeration. Is that delay offending the reasonable sensibilities of the public to reflect respect for dead human bodies?
Thank you.
And I think,
Board
Mr. Bryant, you bring up a good point, because they made arrangements on November 1st, the same day that the decedent was brought into the care of this establishment. And at the arrangements, it was specifically made certain there'd be no embalming. For those of us in funeral service that are embalmers, funeral directors, when I have a family of the Jewish faith, or I have someone who wants an immediate burial with no embalming and all, and once we meet with them, we have refrigeration, we automatically move our decedent to refrigeration if it's going to be any time frame. What I'm questioning a little bit about for those of us who have buried Jewish faith, usually they're buried before sundown the next day. And I see a long period of waiting from the 1st to the 6th. And I guess therein lies a lot of information. Were they waiting for family to come into town? Was it just scheduling? The funeral home was busy. So I'm missing some moving parts there. But my greatest concern is they waited on a family on November 1st. They knew this decedent would not be embalmed due to their faith. They have refrigeration, evidently coolers. And my other thing that I keep questioning, none of the staff could answer why this person had not been moved to refrigeration prior. Was there a lack of communication amongst staff members, or just drop the ball? I don't know what, but I'm finding there's something missing on the respondent's part, especially not able to answer why this decedent wasn't moved to the refrigeration unit.
And Mr. Wheeler, on your earlier question about the why so long from the 1st to the 6th, I do know there was some information that the rabbi that was to be present had some scheduling conflicts, and that the 6th was as early as they could get him there. But so just to help answer that, hopefully.
Okay.
is the board maybe kind of feeling this direction I'm going? And if not, please speak up. But no laws have been violated. So I don't know, definitely not a fine or maybe letter of warning. But Mr. Bryant, with maybe some type of instructional letter, I hate to use the term common sense, but maybe moving forward, maybe prevent this from happening again. Does it make sense, kind of what I'm throwing out there?
It does, and Mr. Lee, I too want to. I try and be very very careful about. I think there are obvious instances when professional conduct has been violated. I think we've seen those. There are others that I think like this one where it's so the situation is so rich of you need to have a lot of institutional knowledge, which I've learned a lot about the funeral industry in my over 4 years here, drop in the bucket compared to what you all have. So I would say I would agree in part with your statement that no laws or rules have been violated. There is certainly no law that's been violated about the refrigeration. Very true. The rule regarding professional conduct may have been violated. And again, that's the difficult question you all are stuck with, is that that going through that timeline, does that trigger the professional conduct violation regarding the reasonable sensibilities of the public? So certainly no law violation regarding a specific, the statute says you have to refrigerate within 24 hours. Nothing like that exists. No law like that has been violated. But whether or not a professional conduct violation, that rule has been violated, that I'm leaving that one all up to you, since this one I think requires a lot of internal knowledge. So I don't feel as comfortable weighing in to tell you one way or another, but so you could still get to a rule violation, I think, is the short version of what I'm trying to say.
Thank you, Mr. Bryant, as always. Board members?
Well,
I didn't want to interrupt anybody. I didn't know if somebody had said something just then or not. How does the board feel on the professional conduct? A letter of warning that may help implement their rules down the road as far as what
And,
may
and
need
Mr.
to be done.
Mr. Leah, that's what Mr. Wheeler here would like to make a motion to the board on the rule 0660-11-005J that we send a letter of warning.
I understand that, Mr. Whaler. Do we have a second on that?
A second.
I have a motion by Mr. Wheeler and a second by Ms. Allen for a letter of warning involving Rule 0660-11-005J as far as reasonable sensibilities and respect for dead human bodies. Is that kind of quoted right, Mr. Bryant?
Yes, that is perfect.
Thank you very much. Ms. Bohannon, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
yes,
Chris Lee.
Yes.
The motion passes.
Thank you. Motion passes. Mr. Bryant, as always, thank you for your diligence and your detail and in bringing these complaints before the board. We're going to move on to the executive director's report. Mr. Gribble, I'll turn this over to you.
Thank you, Mr. Lee, and thank you, board members. Again, I want to express my appreciation to everyone this morning. I know we had some obstacles. It's for those of us, I even had a problem trying to get on for a few minutes there, and Ms. Bohannon helped me. And I appreciate her, and I appreciate her tech staff. And board members, I think you realize this is a new platform that we've been directed to use. It's a safer platform. There were some problems with the other platforms that the state was using to where they could be hacked. People could come into meetings and disrupt them. So in our growing pains, we experienced some pain this morning. I appreciate each one of you, and Mr. Wheeler and Mr. Haynes, I appreciate you for understanding and working hard to get on. So in the end, everyone got on that wanted to get on and need to get on. But I know that also that's, you know, it pains us that it happens, and I think we'll be good going forward. First thing's a legislative update. As we all know, it's getting toward the end of the year, and as the first of the year comes around in Tennessee, the legislative session starts again. So her office has not officially been contacted by. Her office has not been officially contacted by either the Tennessee State Funeral Director and Morticians Association or the Tennessee Funeral Directors Association concerning their plans to pursue new legislation affecting the Board of Funeral Directors and Embalmers during this next session. We proactively invite both associations and any other interested party to meet with their legal staff and our other staff before introducing any bill that impacts the board. Not that we try to encourage or discourage anything, but just so that we can answer questions and have an understanding of what their plan is. We invite them to reach out to us. We'll be glad to meet with them, and we want to be proactive in that. The report of licensees that have been issued. This is a report of licenses that have been administratively approved by the executive director pursuant to board authority for the period of October 10, 2025 through December 5, 2025. We have no closed establishments to report. We have a couple or three that are pending. They haven't furnished everything that we need to get those in a closed status. Ms. Bohannon and one of her field reps is working on that, and we hope to have that maybe at the next meeting. Disciplinary action report. This is a report of consent orders that have been administratively accepted or approved by the executive director pursuant to board authority, and as reported on the October 2025 regulatory board's disciplinary action report. And there were none that happened in September, so we didn't include September on this listing here. All these occurred in October. Very detailed list there of what the respondent, location, violation, and actions were. And as far as complaint numbers for today, as of December 4, there were 28 against funeral directors and embalmers and 37 against establishments for a total of 65 complaints. Mr. President, that concludes my report. I'll be glad to answer any questions anyone has.
Thank you as always, Mr. Robert. Do we have any questions for Mr. Gribble? If not, I'll entertain a motion to accept the executive director's report.
Mr. Wheeler makes a motion to accept the executive director's report.
Second, Don Haynes.
Have a motion by Mr. Wheeler and a second by Mr. Haynes to accept the executive director's report. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee.
Yes.
The motion passes.
Thank you, Ms. Lisa. Do we have any individuals or establishments to appear before the board today?
There are none, Mr. President.
Thank you, Mr. Gribble. We'll move on to election of officers for 2026. As many of you know, we had this discussion openly in our October meeting, and we had one individual request interest for president and one for vice president. So at this time, if there are no other nominations, I would like the honor of nominating Mr. Wendell Naylor for president for the Tennessee Board of Funeral Directors and Embalmers for the year 2026. Can I get a second?
Tim Wheeler, second.
Have a second by Mr. Wheeler. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor, Chris Lee.
Yes.
Motion passes.
Thank you, Ms. Lisa, and congratulations, Mr. Wendell. I know we're in great hands next year. Moving on to vice president, we had one board member express interest in vice president role. I'd like to make the motion, if there are no other nominations, that Mr. Randy Nash be appointed vice president for the 2026 year. Do I have a
Second,
second?
Mr. Wheeler.
Thank you, Mr. Wheeler. Ms. Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor, sorry.
I see his lips moving.
Was that a yes?
There we go.
Yes.
Okay, Chris Lee,
Yes.
motion passes.
Motion passes, and congratulations, Mr. Nash. The next thing on the agenda is we have a board appointment for 2026 for the continuing education liaison. At that time in October, Miss Allen had expressed interest in it, but she explained that since Gupton College has so many CU offerings, she didn't want there to be maybe a conflict and we have to do business another way. So I believe Mr. Haynes has volunteered to continue for another year before I make that nomination, Mr. Haynes. Is that good for you?
It's fine with me.
Thank you, sir. I know Miss Lisa appreciates it and us as well. I'll make the motion that Mr. Haynes be appointed CEU liaison for the year 2026. Do I have a second?
Second by Mr. Wheeler.
Thank you, Mr. Wheeler. Miss Lisa, would you call the roll, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee,
Yes.
motion passes.
Thank you, Miss Lisa. Do we have any new business that needs to come before the board? None heard? Miss Lisa, we've come to the public comment section. Has anyone there or online signed up to express any public comments for this meeting?
No, there's nobody that signed up.
Thank you, Miss Lisa. At this time, if there's no new business or anything, I'll make a motion that we adjourn with the next meeting date being January 13th, 2026 in Nashville. Do I have a second on that?
Second, Don Haynes.
We have a second by Don Haynes. Miss Lisa, would you call the final roll today, please?
Tim Wheeler,
Aye.
Don Haynes,
Aye.
Tracy Allen,
Yes.
Scotty Porsche,
Yes.
Wendell Naylor,
Yes.
Chris Lee,
Yes.
the motion passes.
Thank you, Miss Lisa. Motion passes. Thank you, Mr. Gribble, Mr. Bryant, and all board members for attending today so that we can get this business taken care of. Everyone have a great day and be safe, and thank you.
Thank you.
Merry Christmas to all.
Thank you. Merry Christmas.
Merry Christmas.